Welcome out to our January 27th legislative review. We appreciate you joining. I'm sure there'll be a few others that join here shortly. To get started today, I did want to follow up from one thing discussed last legislative review. We talked for a quick second about this bill, HB 29, on deceptive pricing. And we talked about how it'd be hard to comply if you had to show the final price. But I had read this one a little bit too quickly, and there's two different things defined here. There's total price, which means basically what the supplier is charging, and then there's final price, which includes shipping and taxes and things. And so the law requires them to clearly and conspicuously disclose the total price, which is the price the supplier is charging, and then it says if they choose to disclose the final price, meaning taxes, shipping, and everything else for a transaction, then it has to be disclosed more prominently. So that one, this bill does not require that they, at the beginning, show the sales tax. They can still wait till the end when someone's put in their information. So I just wanted to clarify that quickly because did not quite go through that entirely with all those nuances last time. Let's see. And then we just wanted to move forward and go through a number of bills that either may be of concern or you may like, and talk about some of the principles associated with them as well. So if you have a specific bill you want to talk about, you can let us know and we can pull that up. But otherwise, we'll get going here. First one today that I was interested by. It's a kind of a quick thing to discuss, but well, yeah, a little bit quick. There's a couple points in it. Boating safety education. They now want to make it illegal to operate a watercraft without taking a yearly course on boating safety. And so people that are into, and I guess I should say watercraft is a motorboat or a sailboat. But they want to require this yearly course, and you have to recertify every year. And then they say that a watercraft owner may not rent a watercraft to an individual who does not provide to the watercraft owner proof that the individual completed the watercraft operator safety course. And so I guess it's possible, I don't know the numbers on this, that they're having more boating accidents or there's people driving boats while drunk. It is illegal to operate a motorboat while drunk. And so I don't know if they're concerned about that, but this will make it so that they have that course. They do say in here the course is supposed to be able to be completed in less than 20 minutes on average. But another regulation that they want to add in. One of the reasons, I guess two of the reasons they get concerned about this is just, is it needed? I don't know, again, on the numbers completely. It'd be interesting to know the numbers. But number two, I really don't like to see bills where they start making individuals police others. They do this a lot with laws that exist. They just say, oh, we'll just make the business owners collect the taxes for us. So if you want to sell a product here in the state, or if you want to employ an employee, you are required by law to become a tax collector. You are conscripted without any choice. And the laws more and more are going to a private enforcement regime where we are conscripting individuals, boat owners, or others into now being an enforcement mechanism. And so this is something that you can get in trouble for if you have a boat, let someone else use your boat or rent your boat. That means you can now be responsible because you were delegated to be the police of some of these things. I'm not a fan of being conscripted to enforce laws. I think one of the good checks and balances that exist is that if a law is a good law, the government should be able to enforce it. If it's a bad law, then that might be why they're asking us to do it. But I don't know if you guys have thoughts on things like that. Most of us would look at this and go, oh, it's 20 minutes. We might shrug our shoulders. But I do think this is how they build kind of line upon line and get more and more regulations and just continue expanding something that's existing. And when something's in place and it's accepted for a long time, it's a lot harder to get rid of it. Along though with water safety, apparently, again, I don't know if there's, go ahead.
Austin, I think Seth had his hand up there.
Oh,
Okay. Yeah, just shout out. I can't.
okay,
I'm sharing
gotcha.
my screen. I can't see things well, so go
No
ahead.
worries. Yeah, so I won't claim to have anywhere near a perfect understanding of what exactly is the line as far as what governments have authority to do in terms of safety regulations and so on, or conscripting citizens. I think I do agree with that, that if we're being called upon to police others, then that's problematic. But I see this generally as kind of like, I don't know, I think of it like a seatbelt law in a way. And there are ways in which this bill goes beyond that as well. But my main thing that just has alarm bells ringing when I see laws like this is I just have to ask, what is the grant of power in the state constitution that allows them to do this? And when I ask lay people this question, the response is often something just kind of like hand wavy. Well, health and public safety. But health and public safety isn't even stated as an objective of our state government anywhere in our state constitution. And so maybe it's helpful to just kind of draw some philosophical and moral guidelines to say, if someone is injuring someone else's rights, their life, liberty, or property, then the government can institute laws to safeguard those things. But I don't see where people's rights or liberty or property are being imperiled, objectively speaking, by just not taking a government boating safety class, right?
Well, the one response could be, and this is a real thing that does happen. I've seen some of these situations come through with my legal work. There are boating accidents. Drunk people while driving crash into other boats. People do get injured. And sometimes people get run over while in the water. So if they're out swimming and a drunk driver is coming or someone that doesn't understand they're supposed to look for stuff, they will literally run people over that are swimming. So there is, and again, on Utah waterways, this is why I say I don't know for sure where we're at, because on Utah waterways, the boat usage is going up a lot. As we have droughts, the surface gets smaller, and so more people are packed in. And I don't know if the accident side of things has gone up a lot, because if it reaches the point where there's tons of people getting injured, then maybe we do need a boat license to help with, ensure people's life, liberty, property type thing. I don't know, again, the numbers on that, but I am curious to look at, and I agree, it's helpful to look to the state constitution and some of these other things. It's also helpful, I think, just from a moral perspective to say, do we need government? Do we not? And some of that I do think comes down to, how many people are getting injured? Is it a lot? This bill is also proposed, SB 126, to mandate that we teach water safety in public schools. She wants to make it a public education core curriculum standard that students are getting taught how to swim. They're being offered, if they want, lifeguard certification training, swim instructor certification training. So these are courses that they can take. And so I don't know. I look at it and say, maybe there's a lot of water issues. Maybe people think they can swim, they jump in, they can't. I don't know the complete answer to that. But I do know that there tends to be a lot of friction when it comes to mandating bills for public education because they're already so taxed, you could say, on how many things they're supposed to teach. But I think this goes back to one of the moral questions of let's just assume water is an issue, which again, I don't know it is or not. Do we want to mandate it's in school? Is that a good thing, a bad thing? And it's very interesting to me to go through a number of the school debates about what we should or shouldn't do in school, where we spend our time or not. And obviously, I think that legislative reps are trying, I think many of them are trying in their best judgment to find ways to help people. And I don't know for sure if these help, if you have a swim class, if it makes your situation better or not, or if that should just be left to parents, kids type thing. But you can think about some of those. I don't think they're too controversial. This one is quite unique, though. This one I just more put out there. It made me laugh when I read it. Maybe it shouldn't have. But apparently we have an issue here in Utah where we need to ensure that a child entering public school has personal care independence, is what they're calling it. And so they want to begin it this August. They want it to require that a student demonstrate personal care independence by being toilet trained before being enrolled in a public school. They didn't put any ages on that, so kind of curious if that applies to high school as well. And so in addition to the student being able to demonstrate that, they also want assurances from a parent that the student is toilet trained. So I just feel bad if this bill passes, these poor schools trying to figure out how do you make people demonstrate that they're toilet trained. And I'm sure there's been some issues in Utah schools, but our laws get very, very interesting to me in the ways that we try and deal with things. I would be supportive of something that just says if your child has problems at school, we can send them home and have you provide other schooling options until they can take care of themselves. But a law that says every student has to demonstrate that they can that they're toilet trained, I think is maybe the wrong way to go about it.
That's something I hadn't thought about with this. It does seem rather invasive, and maybe that's something that we don't often think about with these laws is things that sound nice, but how are you going to enforce it? How are you going to, who gets to say and how? That does get rather intrusive, I think.
Yeah, especially when it specifically says the student's required to demonstrate is the language in the bill.
Yeah, that does not make me excited to be a kid again and go to public school. So I'll have my kids go through that.
So, but following up on the private policing of things, when we mandate that individuals police laws, businesses, individuals, here's another example of this. This one wants to require that if you want to get into a bar and you look like you're 35 or younger, they have to ID you. I don't necessarily get a lot of heartburn either way over ID laws for alcohol necessarily. But they do implement that just to get into the bar or tavern, you have to show your age. And so, there's a new, probably more, they have to start enforcing, and they have to do some electronic verification. So this bill does have some electronic verification requirements where they are determining it based on some electronic processes they have. But my concern becomes more that it says that if it appears fake, if the ID appears fake, or the system spits back that it's fake, the authorized person is obligated, it says shall, immediately call and request the law enforcement to verify. And kind of pursue that. But during this process, if law enforcement's coming, it says up here that that they authorize an authorized person to confiscate a proof of age if they determine that it's fake. And so this is one, again, where you have to report it. You then hold the fake ID. And the reason that I get worried about things like this, and I don't like where the government heads with these, is because we're now requiring individuals to act as police officers, essentially. In effect, we're almost, we're kind of trapping a person in a sense if we won't give their license back. And I could see this leading to violence, fights, aggression type things. And most individuals are not trained on how to deal with those things. I mean, just imagine if you're a poor cashier and you scan the ID and it brings up invalid, and then you have to, oh, just a minute, I'm calling the police, and the person is getting really agitated. You don't have guns or tasers on you to protect yourself. You don't have the training the police have on de-escalating situations. And these are things that I've seen quite a bit. If you think back to COVID, all the poor store employees that had to try and enforce mask mandates, we just aren't trained for that as people. And I don't think it's proper for the government to put that on us and say, you're now conscripted to be an enforcer of this law, lucky you. And so I tend to really not like provisions that directly place compliance obligations on normal people like us, because we are becoming at that point forcibly enlisted. We can go to jail if we don't enforce the law now, and we can get in trouble for that. If you're an employer and you don't collect your employees' taxes from their payroll, you can get in big trouble for that, because you're required to be a tax collector. So that one's there. Wanted to give a heads up. And again, if we're putting private enforcement in bar settings, I just feel like we are stirring the pot and putting in potential conflict. Another situation we're doing that, this one is, let's see, HB 72. And this is regulating cryptocurrency, virtual currency kiosk operators, they call them. And we're putting a fair amount of requirements on these virtual currency kiosk operators. So you can go in here and buy $100 worth of crypto, for example, or sell your crypto through these different wallets, or these kiosks, I should say. Wallets are different. And Utah is proposing to regulate these, to say that for certain transactions in Utah, you can't accept transactions from a single customer that exceed a total of 1,000 of cash in a day. So if you want to buy a bunch of crypto, you're going to be limited if this goes through to $1,000 a day that you can get. And you can't buy more than $2,000 worth of crypto until you've completed essentially 5 or more transactions. And so it's kind of to prove that you're real. One of the things they're trying to do, they're also trying to require these disclosures and warnings to say that Warning, consumer fraud often starts with contact from a stranger who is initiating a dishonest scheme that frequently targets vulnerable populations, including the elderly. If you believe you are being scammed, call a local law enforcement officer. Never send money to someone you do not know. So they want this put on anyone in Utah so that they have that available to them. And then they also want, and this one I think is pretty burdensome, that if you're going to conduct business in the state of Utah, you have to, it's a shall, provide a toll-free customer service line available 24 hours per day, 7 days per week. That is, that can be difficult to staff. And I know that we have options in India and Philippines and things, but to me, requiring that these businesses provide 24/7 customer service, I don't know. To me, it's pretty strong government incursion into some of these things.
I've seen several, if I can just say there were a couple of bills last week, one on data centers and another for DNA sequencing companies. And they both of those bills set very steep financial hurdles for like additional regulatory hurdles, things that could really hurt small business owners in particular if you were trying to get into that space. And it seemed like the practical effect of that was to guarantee that these types of industries would be monopolized only by the giants with national backing or other deep pockets. Because if you're a business owner, you say, I want to get into this business, and you say, oh, wait a minute, I've got to do that. That just added a huge, line item expense to your P&I sheet. So it's not really feasible. And that's
Right.
especially troubling given Utah's free market clause, but I haven't really seen that be upheld, unfortunately, in the courts.
Yeah, the many of the consumer protection laws just add regulation and make it more and more difficult for the small guy to start up, and they do decrease competition quite a bit. So it's one of the reasons why I bring up some of these is because sure, it's nice if there's a warning, but when you go through it state by state, if you want to start a virtual currency kiosk and you're limited to $1,000 a day that people can exchange through it, you have a very slow start. You have to be well capitalized, to your point, to staff these call centers. And then we don't think about this often, but when Utah imposes their regulation like this, you now have to code every state to treat people differently. So if you're the company and all 50 states pass their own thing, one of them says $1,000, one of them says $950. One of them says your disclaimer has to say this because we don't like Utah's disclaimer. One of them says you have to staff customer support in the United States, whatever it is. You are coding a website to try and appear different to 50 states based on where people are logging in. It becomes very difficult. Another very difficult thing about this and compliance is that many people that use virtual currency opt to use VPNs as well, virtual private networks, and block where they're really coming from. And so the level of compliance burden this imposes is quite high. And I'm not saying that we should just let businesses do whatever they want, but I do strongly believe that we always need to have a way for competition to arise in an existing space. Otherwise, we create monopolies or oligopolies or whatever, where there's just a few that can make it work because we've made it so complex. And so when I look at this, yes, it will probably help a few Utahns not get scammed. Maybe there's a lot of Utahns that will help. But it's also starting to train us that, oh, I can only do $1,000 a day. And when we let the government decide how much commerce we can do per day or how much crypto we can purchase that day or whatnot, to me, it starts to lead to a place that of just the government regulating too much. And yes, I can lose money, I could lose money when I gave cash to people too. That's a risk of life. And I get concerned when we're trying to stop every single risk of life from occurring for people. Let's see, this one's a hot topic with the Utah Bar. I was curious to know if any of you have the same concerns that the Utah Bar has with this. So there's two bills. I haven't pulled up the other one. There's one bill that's proposing to add, I want to say 2 justices to the Utah Supreme Court, taking it from 5 to 7, I think. And then this bill is proposing to add judges to the district courts. Those are the trial courts, the juvenile court system, and the Court of Appeals. So you can see here the increase. The 3rd judicial district is Salt Lake County and Tooele County and one other, Summit maybe. And they're proposing to go up by 3 judges. When you're in a trial, you only hear, and at the district court level, you're only in front of 1 judge. So it won't change for you what the court looks like if you're in a trial here. But they say the courts are backlogged, need more judges. And so they're proposing to increase these. Some of these are smaller. 4th Judicial District Court is Utah County area, as well as 2 or 3 other counties. And it would only go up by 1. But I do know, based on my experience in court, there are some judges that you try and schedule an emergency hearing that by law is supposed to be heard within 10 days, and they take 3 months to get it scheduled. So it appears like they have a backlog, and that they're not scheduling things super quickly, and cases are taking a very long time. So maybe we need more judges. I'm sure that the number of case filings has gone up as the population's gone up. But they are proposing to also increase the Court of Appeals from 7 to 8 judges. And when you have a case on the Court of Appeals, they will assign a group of 3 judges to hear your appeal there. The Utah Bar feels that the intent of this is to start to stack the courts with more judges that will follow the legislature and governor more closely, especially on the Utah Supreme Court level, where they want to go from 5 to 7. And the legislature response says, no, that's not the intent. The intent is to keep things moving faster because we're getting so backlogged. My response to the Utah Bar on their concerns is, well, the governor has appointed every Supreme Court justice for the last, I don't know how long. And so maybe they're regretting their choices and want to put in 2 different ones. I don't know. But I'm not sure that 2 Supreme Court justices would completely sway things. I haven't followed the Utah Supreme Court quite enough to know where they split or don't split on things. And so that's a possibility. We certainly had a court packing attempt back in under FDR when he wanted to put 15 justices on the United States Supreme Court. And that one was pretty openly to appoint 6 new justices that would hold in favor of FDR's legislation and things he was trying to do. So we have that possibility. Utah did, in the last couple of years, change the judicial nomination process. They made it so that they can have more control over who's appointed than they did before. And so, you know, this could be following from that. And the courts are certainly not in the favor of the legislature right now. So I know the Utah Bar is quite concerned that it's a very political move and that it's meant to change the power balance between the courts. And the legislature's downplaying that, saying, no, it's about efficiency. So I was curious if any of you had any burning thoughts on judges and the number of judges we should have.
Austin, I excuse my ignorance here, but you said these district court judges, you only meet before 1 at a time.
Yep.
So it's not like they all get together and vote on the same thing.
No.
So I don't understand how you're packing a court by adding more individual courts as compared to the, the Supreme Court where they all meet together and vote on something together.
Yeah, the theory would be if you could somehow finagle things to get your case that you filed in front of one of the new judges, even at the district court level, then they may be ones willing to hold however the legislature wants.
So that would be the issues you'd have to be able to get to the judge you want.
Correct.
Is that possible? Can you do those kind of things?
So if you read about it, it's interesting. They call it forum shopping for judges. There are some people that seem to be very good at it. In theory, you're supposed to be randomly assigned to a judge when a case is filed. But it is interesting if you follow certain high-profile constitutional cases, they seem to always land certain judges. So I don't know if some people have a way to land in front of a certain judge. I don't. I know if I file a case, it's just whoever the system assigns me. And as far as I know, the system works that way. But there's certainly, I look at some of the cases that have been filed and the judges they land in front of, and I just go, wow, that's hard to believe that was just pure luck of a draw. Maybe it was. But it has been interesting. So if you look at the challenges to Utah abortion and laws, for example, they'll end up in front of some very favorable judges at the district court level that have stopped it from being enforced this whole time so far. Maybe it was coincidence, maybe it was random, but I don't know. And I think that there's enough just talk about it online. Usually it refers to forum shopping, usually refers to choosing whether you're going to file in the 3rd district court or the 4th district court, because do you want your chance with the 14 judges there, or the 35 judges in the 3rd judicial district court, assuming this bill goes through. And some people will choose which district they file in based on the likelihood of getting certain judges. But I don't know beyond that if people have a way or not. To my knowledge, they're not supposed to. It's supposed to be random. But I guess even adding 3 more, it's almost 10%. So it changes the randomness by 10% in the 3rd judicial district court where most constitutional challenges are filed. But it's a good question. And again, 7 to 8 judges. The one judge I don't think is going to change the, one isn't enough to throw off a 3-judge panel on the Court of Appeals. So I'm not crazy concerned personally about increasing this. I just know that the Utah Bar is quite concerned about it. At least the Supreme Court level for sure. This bill, let's see, HB 68 goes through affordable housing. There's going to be a number of affordable housing bills this session. It's, according to the polls, it's Utahns' #1 thing that they want our legislature to address. They want housing to be more affordable. And I always feel that we should be cautious with this because when we want the government to make something affordable, what are we really asking the government to do? And here, this bill sets up, I guess we're down here a ways in the bill, but it sets up the division of housing. There's already a division that's doing similar things in Utah. We're rebranding it. We're getting rid of the old one. We're creating this new one, giving it a lot of the same obligations. But we're creating a whole new government entity. And we want it to do things like have a state housing plan, assist housing authorities in carrying out the housing authorities' responsibilities, assist in the development of accessible housing when requested, make rules about getting affordable housing in. I shouldn't say affordable housing. They call it moderate income housing that they're pushing for. And this means housing that someone that's at 80% of the median income levels could be able to occupy. So it doesn't say that they have to be able to purchase it, just that they can afford to occupy it. So I think we see this around Salt Lake County a lot. There's a significant number of high density homes going in, a lot of townhomes, condos, end-to-end type subdivisions. Many of them don't even put in enough parking for the people. And you'll see the streets crammed with people trying to park because they'll put in one parking spot, but most people have 2 cars, and so they just don't fit. And we're pushing for this, and there's pushback as things get built. We have things such as the travel industry where people buy up Airbnbs and they use them for short-term rentals. You know, some people accuse that of driving up the cost of houses. Some people accuse foreign investment purchasing things from driving up the cost of housing. But it's interesting because Utah has tried for a long time to make itself a state where people want to be. And once people start moving here and the cost of housing goes up, we now don't like the effect as much of encouraging all these people to come here. But the concerns I have as we start to get into the government highly planning out and enforcing housing and different things is we're starting to get in, we're removing ourselves more and more from the free market. And even on the free market side, we often do things that make developers a lot of money. So many communities do not want the high density housing because it brings its own problems with it. And they try really hard not to have that. The developers want high density housing because they make a lot of money off of it. And I'm always interested to see that we're coming up with proposals that mostly push towards things that make developers a lot of money in this process, rather than maybe addressing some of the zoning laws that exist. And so, for example, West Valley City passed a new zoning ordinance a number of years ago that mandated that your home, if you're going to build a new home in West Valley City, it has to be a certain square foot size, the minimum square foot sizes. You can't build a smaller home unless you get approved for the high density housing type stuff. But what that did is that zoning law alone drove up the cost of housing significantly, where you know how to build a certain size. And every time we do things like that, every time we pass new safety standards and regulations, this, that, and the other, the cost goes up quite a bit. And even to give an example that I've always felt was interesting, that we don't talk about much, that drives up costs, especially in construction, is every company is obligated by law to have workers' compensation insurance in place. And that's in the event that the employee is injured on the job, there's a way to pay that employee for to compensate them for the damage or whatever happens to them. But if you're a company that provides health insurance for your employees, so you're paying for health insurance that would cover them in the event they got injured, you also have to double pay for workers' compensation insurance. And I look at that and I think, why should an employer that is providing health insurance have to double insure with workers' comp? Because in construction, workers' compensation can be extremely expensive for these companies to provide workers' compensation insurance. And oftentimes people end up getting covered for on-the-job injuries, but not off-the-job injuries, and they don't have great health insurance because the employer is using so much of the money for workers' comp for the double insurance, essentially. And so I'd be very interested in saying, well, can we help the free market work better in good ways? Again, I'm not saying that any developer should be able to come in and build whatever they want, because you do have to plan for sewer, you do have to plan for water, load capacity, all kinds of things. But to me, most of the process and discussions aren't about how to create the right balance between all the competing interests. It's more, let's do things that promote high density housing. So something to watch out for. And again, this one, we already have a division. Let's see if we can find what it's called. It's in one of these here, where they cross things out. We used to have, used to be called the Housing and Community Development Division. And they're changing it to having a community development division and a division of housing. So they're kind of separating out the two. So if this bill goes through or not, a lot of this is already happening in the state. And there's a lot of very high level plans where Utah governor's office of Economic Development, which is run by the governor, they're planning how to develop out our entire state, at least the parts that are left. And it's a very high level thing. Maybe that will make us a really cool state that everyone wants to come to. But it may make it so that we're also highly regulated and lose more of the freedoms that made Utah what it was in the beginning. So those are some to be aware of there. This one, I struggle with bills like this, so I wanted to bring it up. This is HB 85, State Sovereignty Amendments. And as a disclaimer, I fully support state sovereignty. I really am a fan of that. And I think that there's a number of representatives that push that as well and say we're going to go up and be sovereign. And so this bill says that the governor or chief executive officer of a political subdivision, so like a city or county, can't declare a state of emergency exclusively in response to an international organization's proclamation. And then they say that an international organization has no power, jurisdiction, or legal authority in the state. So if you come down, they define international organization to be the UN, the World Economic Forum, or the World Health Organization, which the US just withdrew from. There's always the chance we get a new president and we're back in that, but currently the US is not in that. But if you look at the language and the legal impact of the language, it says that, and it says this for governor later too, but it says that they can't exercise the powers under this chapter, which is to declare a state of emergency. You see that up there, it's to declare a state of emergency. It says exclusively in response to an international organization's proclamation. And the reason that I struggle with these types of bills is because any bill, even though I am an attorney, and maybe I should like more legal work, any bill that makes you go talk to an attorney to do what you want to do, I don't think is a great thing if we're just wordsmithing, because now all that we have to do is just say, well, it wasn't exclusively for that reason. We have two reasons why we're doing it, and declaring the state of emergency. And so this to me doesn't change anything. It only makes it so that as long as their attorneys help them craft the language correctly, they can still do whatever they want to do. And I don't like feel-good bills that don't really change anything and that just encourage people to talk to attorneys more and make their language more politically correct. It does go on later in the bill to say that this is a little bit stronger of a statement, but in practice, I don't think it changes anything still. It says that an international organization does not have any power, jurisdiction, or legal authority in the state. And that, to me, is, again, a good thing. But if you want to implement something that an international organization is doing, you just have to change the name or change a thing or two with it. Again, just wordsmith it a little bit, and you can still do whatever you want. So when I look at these, I go, I really don't like bills that push us to be more more politically correct, where we just have to say things perfectly. I'd prefer that people are just honest and we look at that. And in reality, I have deep issues with allowing mayors, governors to issue states of emergency in our current society. The reason, the theory behind states of emergency before, where they could take control, was that there was something that prevented the legislature from meeting. That was, super pressing. And so I talked a lot about this during COVID, because they kept, they worked to, well, should we limit the governor's power a little bit? But in the end, they kept the governor with power to declare states of emergency, even though the legislature is fully capable now of all meeting online and voting. They had electronic sessions and votes. They still, to this day, allow reps to participate electronically in meetings. They can vote, they can do different things, and they don't have to be present. And I look at that and say, the governor in our check and balance system should have no power to declare a state of emergency unless the legislature is incapable of meeting to vote on something, in my opinion. Because to me, the legislature, the county council, city council should be the ones voting for how to deal with things and be subject to the typical process. And if they need a faster process to do certain things in response to, issues that come up, we could talk about that. But just to say, we're going to continue to reinforce that the governor, the mayor, has the power to issue these emergency declarations, states of emergency. I don't love reinforcing that personally, and I don't love the wordsmithing that bills like this produce. So again, I support state sovereignty, but I don't feel this bill changes anything other than to give some political hurrahs where they can make a claim that they did something good for state sovereignty or whatnot. This is a bill. This one's. I think we're going to see a lot more of this. So this is called public speaking amendments, and this one is going to impact our society a fair amount. And whether or not they pass the bill, we still have to deal with the bigger societal issue that's coming or that's here with this. This one's proposing that if anyone wants to come speak at or conduct an event, public event at a college or university, which are pretty open to events, you can schedule one of those, go in and do your event, that the university has to go through a risk assessment. They have to determine the level of threat. They have to coordinate with the Department of Public Safety. They have to mandate security measures based on the threat level. And obviously this is coming in response to Charlie Kirk and the shooting that happened. But what starts to happen is other groups in the law, there start to be claims that you were negligent if something violent happened at your event. So if you're a small group, again, this is kind of to the small point. If you're a small group and you get 50 people together and someone pulls out a gun or a knife or there's a fight, if you didn't hire security, are you going to be negligent and liable for that? Are you going to get sued? And the more that we start to mandate security measures for events, the more and more society is going to start to say, yeah, it's negligent for you to host an event without providing security measures. And the reason, again, I'm deeply concerned about that is because if you're a smaller group you want to start something, you want to be politically active, you want to get some people together, you can get derailed by a protester showing up and punching someone, and then you getting sued for it. And it gives a lot of power to groups that are willing to agitate violence, because then you have to have the money to hire security. You have to have your security plan, your security protocols in place. And again, in certain events, we kind of expect it. If you're going to a huge event, we expect there to be security. But we haven't fully expected it at our local spelling bee or a community forum to discuss politics or whatnot. And at some point, though, if we continue down this path and we don't start to really, distinguish between, hey, you're a small person, you don't need to have security at your events till it reaches, I don't know, 10,000 people, something like that. The law is going to, and society is going to start to push people to be more and more liable if things happen. People are always hungry for someone to sue. If someone makes a bad decision and punches another person or shoots another person, we want to blame everyone else but the person that did the bad thing. And the person that did the bad thing, it's interesting because there's a lot of people that say, well, they've got to have a mental illness. We should go treat their mental illness. We shouldn't punish them. But how dare you not have enough security to stop that from happening? And so it's a very harsh double standard, and it makes it concerning. I know of some groups, smaller groups, that after the Charlie Kirk shooting felt they needed to hire security for an event. And it's an uncomfortable thing, and it's expensive to not know fully if you're going to get sued or not if someone does something they shouldn't. So again, society is going to start wrestling with this, but I think we have to have an eye towards the fact that humans get together. I don't think we want security at every single event. Do we want security to be present at every child's soccer game? Maybe we're getting there to a place where it needs to be. I don't know. But I hope as a society we can figure out how to still keep general community level stuff functioning and working and separate out other things. And this bill does not, this bill mandates it for all events. There are obviously different threat levels, so you may be classified a low threat level if you're a small event. But if your event is taking place on a college campus, then you could become subject to this if it goes through. This one, though, I think is a good bill. This one, so currently in public schools, they assign devices to your children. The devices are set up to work with all the teachers and all the homework submission and all that kind of stuff. But parents don't have access to control that device. It's just solely controlled by the school. So as an example, we can put screen time limits on our devices here at home, but any child's public school device, you can't put the same screen time limits on. And they can still do things on it or be up later than you want them to on the, or whatnot. So this is at least putting in that all school computers that are given to kids need to have parent accessible monitoring systems. So at least a parent can see what their kids are doing on the computer, because before they didn't even know that. And the parent can also require certain pre-approved content filtering systems. I'd still like, parents to be able to have some more control over these devices, such as limiting screen time and hours their kids can be on it, connection to the internet, that type of thing. But I think this is a good step forward. So I do support that. This one, this is an interesting thing. This is talking about any business that's filed, so any LLC or entity that gets set up, along with any license that someone gets from the state. They are mandating and this is already happening to an extent, but they're making it very express that the division shall, is obligated to, sell to the public in bulk or through subscriptions, copies of each filed record in every medium available to the filing office. So government comes in and says, we mandate that you file an entity in order to have certain protections. We mandate that you file an entity for XYZ purposes. We mandate you get a license. And then now those filed records, we're going to sell them and give people all your information. Again, these are public in a sense, in that you can look up a business, you can look up a license. But I just don't love the government being in the business of selling the information that I was mandated by law to give them. Just me. But it can raise revenue for the state, right? And lower our taxes if we sell our information. And to give you some insight into this, states were selling all your driver's license information for quite a few years. They would sell your social security number, your birth date, they'd sell all kinds of things with your driver's license information. And the federal government actually put a stop to that. The federal government came in and passed a law that banned states from selling driver's license information because it was impacting so many people. But that was the thing for a while. States made a lot of money off selling your driver's license info publicly. And then this one, we can end here. This is another one I support, that she wants to specify that it's not unprofessional conduct to refuse to participate in the execution of a death sentence. I think professionals should have a moral right to opt out of things that they don't want to be a part of. I think this should apply to a number of things, where if you have strong moral beliefs about a situation or what someone's asking you to do, I believe that a professional's right of conscience should always prevail in these situations. I don't think a physician should have to assist an abortion, for example, or should have to. I don't think a pharmacist should have to dispense morning after pills or other things like that. And I think that as a society, we're big enough and diverse enough that we certainly don't need to force anyone to violate their conscience or risk losing their license, because there's plenty of others that will step up and do it. So SB 80 is one that I do support, but I would also like it to be expanded just to say you don't engage in unprofessional conduct by refusing to provide a service that violates your conscience as an individual. So any questions, thoughts? There's obviously more bills, but we'll just keep pounding away through them each session, or each time we meet each week. And so you can reach out to your reps, tell them yay or nay. It's a good thing just to shoot them a short email. Let sponsors know if you like a bill. It's often harder to persuade a sponsor to drop a bill. It does happen, but usually you're going to talk to other reps besides the sponsor if you don't like the bill, trying to help them see why. But you do have the potential to be involved and influential. So I certainly encourage you to try and do that. But again, let me know if you have any questions. You can shoot me an email to follow up if you want as well. And I appreciate you being on.